Plug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys.
Well, hello there to all the good people of Ohio and beyond. This is Aaron Knapp, and you're tuned into Unplugged, broadcasting without permission. This is a place where the truth gets louder and we dig deeper, and where we always remember, be lawful, not awful. If you want the full stories, the documents, the videos, and everything they don't want you to see, head on over to AaronKnappUnplugged.com. My new home for every investigation, every episode, and every update. And while you're here, be sure to like the video, follow the page, and hit subscribe. And share this with someone who needs the truth. We're building something real here. We're building something fearless. And we're doing it together. Welcome to Unplugged. Let's kick this thing off.
Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise.
Alrighty there. Good afternoon, good evening, good morning, Lorain County and beyond. It's Aaron Knapp here. I'm broadcasting before a live studio audience today. Actually, that's incorrect. It's just me and my dog here. I'm going to go ahead and record this video because it's going to be kind of long, and I thought maybe I could break it down in a few different sections for you guys. I know it's not my usual way. Usually I just go live, but we're going to do this one pre-recorded and see how it works out. But it's going to be in regards to pretty much everything that's been going on with my case and the city and the county, newly discovered stuff, old stuff. And as usual, it's going to be a doozy. So let's just go ahead and kick this thing right off. And we're going to talk about the case was contaminated before it ever was even charged, right? This did not begin with a clean investigation. It did not begin with a neutral prosecution. It began with a government that had already been watching me, writing about me, collecting my complaints, forwarding my name through official channels, questioning my professional status, challenging my media status, restricting my access to public buildings, fighting my records request, and treating my disability response like evidence of criminality, after they had already been put on notice of the very conditions that continued to trigger all of those conditions. Now, this is the part that the public really kind of needs to understand first, is this case is not wrong simply because I disagree with the charges. It's wrong because the process was contaminated before the charges were ever even brought or filed in court. The same public officials, police actors, and law department attorneys, court-connected administrators, and government witnesses who had prior involvement with me, prior disputes with me, prior exposure to my reporting, prior knowledge of my disability paperwork, prior interest in defending their own conduct, are now embedded in the very same criminal process that seems to be being used against me. Now, I don't know, last time I checked, that wasn't how justice was supposed to work. But hey, a prosecution is supposed to be detached, right? Supposed to be neutral, supposed to be handled by people who are outside the controversy, right? Not the very officers and actors whose own conduct is part of the whole story. My attorney's motion says the quiet part out loud that he filed recently is that the Lorain Law Department is not standing outside this controversy. It's embedded in it. The motion that he filed in all of the cases, all 8 of them now, explains that these criminal cases are not isolated misdemeanor prosecutions arising from some neutral police file. but they arise from a broader and continuing course of conflict between me and the city of Lorraine involving civil rights litigation, public records disputes, city hall access restrictions, municipal property bans, ethics and complaint matters, law enforcement communications, media dissemination concerns, outside counsel conflict determinations, and post-hearing criminal escalation. Now, that language matters because it does not ask the courts to take my word for it, right? It identifies the structure of the conflict from the record itself. The players aren't random here; they're reoccurring, and that's the thing. The Lorraine Law Department appears across the same factual universe in multiple roles. Its attorneys have acted or may have acted as civil defense counsel, municipal legal advisors, police legal advisors, public records decision makers, protection order participants, witness adjacent counsel, appellate counsel, supervisors of conflicted attorneys, and criminal prosecutors. Now, the motion identifies that overlap as the problem because the same office cannot fairly defend the city's prior conduct, manage records relevant to the defense, advise the police, interact with witnesses, protect city officials, and then ask the court to trust it as a detached prosecutor in criminal cases against the same person who challenged all of that conduct. That's not personal complaint. That is not a personal complaint that I do not like a prosecutor, right? It's not even a political complaint that I do not like City Hall. It's not me saying that every person involved is automatically corrupt because they work for the government. The issue is much narrower here, deeper, way more serious. The issue is whether any responsible person could look at this record and believe that the process remained fair after the same multiple legal structure that I accused of of records obstruction, retaliation, dual role conflicts, lack of candor, supervisory failure, and structured bias continued forward in criminal prosecution without disclosure, screening, outside review, or independent referral. I mean, kind of seems that way. But hey, the law department was warned, and that's a critical fact. The motion states that, my lawyer wrote on December 29th, 2025, we sent correspondence to Patrick Riley, the law director, and Riley had asked, hey, well, what do you think we did wrong? And so he was placing Riley and the law department on written notice of alleged constitutional violations, public records obstruction, retaliation, dual role concerns. Dual role concerns is very important here. Structural bias concerns and supervisory failures. That notice came before the March 11th, 2026 Butler hearing where they were trying to come after me in civil court, before the whole safety service director protection order activity became in play, before the March 20th municipal criminal filings, and long before the phone warrant and passcode communication issues. So the city can't pretend this conflict issue was invented after I was charged. The conflict was identified before the criminal escalation moved forward, and that timing matters because it changes everything. Once the law department had been placed on notice that its own conduct, supervision, records, practices, and overlapping roles were being challenged, the fair thing to do, God forbid, but the fair thing to do would have been to stop and screen the matter. The fair thing to do would have been to disclose who had touched the case. The fair thing to do would be to find out who advised the police, who had communicated with witnesses, who would handle public records decisions, who had participated in city hall access restrictions, who had reviewed body camera or other evidence footage, who had discussed protection order strategy, and or who had any prior involvement in the civil or the administrative disputes. Instead, the same structure kept moving. And that's why it feels less like justice and more like momentum. The government built a narrative about me over time, and then every later event was interpreted through that narrative. When I filed records requests, I was treated as a problem. When I complained about officials, I was treated as vexatious. When I reported misconduct, the system collected my complaints and circulated them. When I published, they called it harassment. When I challenged access to public records, they have tried to ban me from municipal property. When I defended myself in court, my ability to write structured legal arguments became suspicious. When I tried to report the safety service director, nothing moved with urgency. When the city connected people complained about me, the system moved with force. And that's the lack of fairness at the center of this story. The official becomes protected. The critic becomes prosecuted. The complainant becomes the defendant. The records requester becomes the target. The disabled veteran who gave them the paperwork becomes the unstable person they claim to fear after continuing to trigger the very condition they had notice of years prior. Hey, and the court connected pieces cut even deeper, because this is not limited to City Hall or the police department. The records show that the juvenile court leadership and the court administration had already been pulled into the narrative about me long before the current prosecution. We had Tim Weitzel's July 14th, 2023 email to my ex-supervisor Michelle Sims at Applewood that stated that the court identified concerns regarding me as an Applewood therapist assigned to the Crossroads program, referenced as, quote, the officer of the court accusation, and said that after careful consideration of the elected judges, that's key, the court requested that I be removed from the Crossroads program and replaced with another therapist. Now, that's not background noise. That's a court administrator invoking the court and elected judges in communication that affected my professional role and employment. So when I say this has been coordinated, I'm not saying every person met in a smoke-filled room and signed one master plan. I'm saying the records show a functioning network of government actors and government-adjacent actors who watched, shared, forwarded, interpreted, characterized, and acted on information about yours truly. Now, the juvenile court administrators and the judges were involved in employment consequences. Police leadership was involved in licensing board communications. The law department was involved in records, civil defense, police advice, city hall restrictions, and prosecution. Now, city officials were involved in municipal access restrictions and public narratives, court proceedings, and the next part of the next wave of the criminal and protection order escalation. Now, that's not one isolated event. That's a system. The surveillance part is not paranoia when the record shows collection and monitoring. The city and the county had my complaints. They had my filings. They had my emails. They had my videos. They had my disability paperwork. They had my records requests. They had my public comments. They had my social media content. They had my court filings. They had my professional history. They had my communications about my license, my work, my guardian ad litem role, my conduct at public meetings, my city hall access, and my reporting. They watched, they saved, they forwarded, and then they used the accumulated file to interpret every future act as part of a narrative they had already written. That's what makes the criminal case so dangerous. A fair prosecution starts with evidence and then asks whether the enhanced evidence, approves the crime. This prosecution appears to have started with the person the government had already decided was the problem and searched for the legal theories to match that conclusion. First came the narrative, then came the ban, then came the hearing, then came the protection orders, then came the criminal charges, then came the phone seizure, then came the sealed affidavits, and then came the new tampering and obstruction allegations. Now the structure is backwards. And that's why the process cannot be trusted without full disclosure and independent review. The March 11th, 26 hearing is just a turning point because it shows how all of the civil disputes move forward. From criminal framing, the city came into court defending a sweeping municipal property directive, right? The hearing involved city process, public meetings. They claimed authority to restrict me from municipal property. And the city's position that my conduct justified that restriction. After selected video evidence was presented, the magistrate stated that she was appalled and that behavior could be the subject of a civil stalking protection order. They went and did that right after. And that it may rise to the level of a criminal matter. They did that right after. Bowels and bowels. Makes my bowels feel weird. Anyway, at the same time, the court also recognized that the city didn't appear to have the proper vehicle to ban me from City Hall or any municipal building at that point because they hadn't done anything. They hadn't done X, Y, Z. And that's why this whole roadmap issue matters. I'm not saying the magistrate ordered charges. The motion's careful on that point. The issue is whether the city's legal and law enforcement structure used that hearing as a practical roadmap for later protection order activity, criminal charging, warrant activity, and phone search issues. And, my attorney's motion pretty much states that after March 11th hearing that the safety service director's ex parte protection order issued on March 12th and the municipal criminal cases that followed on March 20th and the phone warrant and the passcode issues followed after that. That sequence matters because the same city legal structure that has defended the municipal property directive and heard the court discuss possible protection order and criminal consequences was later involved in the criminal protection or prosecution structure. I mean, all of them were present, including Galinas. The conflict's not hypothetical when the same attorneys and officials keep appearing. Scott Bowles defended the city's civil position and the municipal property directive and the city hall access. Then he appears in the criminal prosecution structure. Joseph Levesque was present at the March 11th hearing, challenged my media status by arguing I was not a, quote, legacy media. I'm not even going to get into that bullshit. And then it appears as the same law department structure that also advises the police and participates in city legal strategy. Patrick Riley, as law director, supervised the office after being placed on written notice of the conflict concerns. And then we've got Lieutenant Kyle Galinas, who appears in the warrant and the criminal escalation after a much earlier involvement in communications about me. And then we have our safety service director, who is both a city official involved in the underlying incident and protection order participant, and a protection order participant, two separate things. Mayor Bradley was present at the March 11th hearing and is now part of the city power structure that had been involved in the broader controversy. None of these people are outside the story. That's why the public should be uncomfortable at minimum. A prosecution involving a person's liberty must be insulated from self-defense by the government. It cannot be used to protect the city from criticism. It cannot be used to clean up a bad municipal property ban. It cannot be used to validate years of public records fights. It cannot be used to defend officials whose own conduct is in dispute. And it cannot be used to turn a disability symptoms into criminal evidence after the government had 2 years of notice. It cannot be used to convert journalism into harassment because the reporting embarrassed public officials. The city may try to isolate each issue. It may say the civil case is separate, the records disputes are separate, the March 11th hearing is separate, the carry-on matters separate, the protection orders are separate, the phone warrants separate, the media issues separate, the disability paperwork separate, the new tampering and obstruction charges are separate. That's exactly the compartmentalization that my attorney's motion warns against. The motion states that the cumulative picture is what matters because the same municipal legal office appears across civil defense, public records control, police advice, witness adjacent matters, protection order issues, media-related concerns, outside counsel conflict, determinations, appellate litigation, and criminal prosecution. And then that is the introduction to the case, right? It's not a clean prosecution, guys. It's contaminated process. It is a governmental response to a critic that moved through records, licensing, employment, court, city hall, disability notice, protection orders, warrants, criminal charges, and now new felony allegations. It is wrong because the fairness requires distance, and this record shows proximity. Fairness requires neutrality, and this record shows overlapping rules. Fairness requires disclosure, and this record shows sealed affidavits and disputed records. Fairness requires equal treatment, and this record shows my complaints minimized while complaints against me were escalated. Fairness requires accommodation when disability is known, and the record shows repeated triggering after notice. The question is not whether I'm easy to deal with. The question is whether the government is allowed to build a file on a critic, circulate that file through official channels, ignore disability notice, attack his professional status, restrict his access to public property, challenge his journalism, prosecute his reaction, seize his phone, and then pretend every actor involved was neutral. My answer is no. No. How about no? Anyway, the record will explain why. And, and I'm going to explain that after a word from our sponsors. Here at Unplugged with Aaron Knapp, we like to thank our sponsors. We have a few unofficial sponsors tonight, and they are definitely not paid sponsorships. I want to throw out there a big thank you to Joseph Jones and Eric Jones of the Lorraine Daily and the Vermilion Daily. They have a local news page. You should check them out. They do plenty of great work broadcasting all the news that is the news that you want to have in Lorain and Lorain County. So check them out. Also, please, if you need any legal services, feel free to reach out to Robert Gargas. You can find him listed online. He's a fine attorney and comes highly recommended by yours truly. And last but not least, I want to mention D&C Radio. Please make sure you check out one of the up-and-coming internet hip-hop stations and all of their shows. They put on a lot of shows. You have the Never Outdone show. You also have the Eric Bowen show, Speak Up, Speak Out. So please make sure you guys check them out as well if you're looking for your latest and up-to-date hip-hop artistry. Thank you for tuning in. This has been a non-paid sponsorship brought to you by Unplugged with Aaron Knapp. Here at All right, that brings us back to the beginning of Section 1. This was never a clean prosecution, folks, and this case should be not introduced as a normal criminal case because the record clearly shows that it does not support that framing. A new prosecution begins with a neutral investigation, a detached review of evidence, and a prosecutor who stands outside the underlying controversy. Sorry about that. That is not what happened here. What the documents show is something a little deeper and much more dangerous. The same government actors who were criticized, sued, reported, challenged through public records requests, accused of retaliation, placed on notice of disability issues, and confronted over City Hall access later became part of the same machinery used to investigate, restrict, charge, and prosecute yours truly. Now, that's why the first question is not whether the government dislikes me. That question is kind of, too small. The real question is whether the government can fairly prosecute someone when the people inside the prosecution structure were already part of the dispute. The motion filed by my attorney today puts that issue directly in front of the court. It states that the Lorraine Law Department is not standing outside the controversy, right? It's embedded in it, kind of created it, We didn't start the fire. Anyway, and that the criminal case did not arise from a neutral police file, but from a broader course of conflict between me and the city of Lorraine involving civil rights litigation, public records disputes, city hall access restrictions, municipal property bans, ethics and complaint matters, law enforcement communications, media dissemination concerns, outside counsel conflict determinations, and post-hearing criminal escalation. That's not a starting point. Well, I mean, that is actually the starting point. The criminal case isn't out here floating by itself. That was the starting point. It's attached to everything that came before it. It's attached to the city hall ban. It's attached to the public records fights. It's attached to the professional board complaints. It's attached to the emails. You can't get around it. It's attached to the court-related employment consequences. It's attached to the disability notices. It's attached to the March 11th hearing. It's attached to the warrant. It's attached to the protection order escalation. It's attached to the new tampering and obstruction allegations. The government wants to split those things into separate boxes because the separation protects the story they want to tell. The record actually does the opposite. The record ties the boxes together. The conflict motion cuts straight to that problem. It says basically that the issue is not a generalized complaint that, Aaron dislikes the prosecutor, and it's not an argument that a municipal law department is automatically disqualified whenever someone sues a city. The issue is a little more specific and more serious. The issue is whether this law department, the Lorraine Law Department, in this factual setting, can fairly prosecute Aaron Knapp while simultaneously defending Lorraine city conduct, protecting the city officials, controlling access to the records, participating in related legal proceedings, i.e., the gun lawsuit, advising law enforcement, Mr. Levesque, responding to allegations all over, and then appearing across the same events that now form the basis for the prosecution. That's not an abstract legal theory. That is a factual posture created by the city's own conduct, period. And the motion identifies the bias contaminant clearly, sorry. It states that the problem is not my protected activity itself. The problem is the Lorain Law Department's overlapping role in the same events, records, disputes, proceedings, witnesses, and the city's conduct that I challenged. So you bring it into plain English, the government's trying to treat my criticism as the reason to ignore the conflict when the criticism is actually part of the evidence showing why the conflict exists. And I was not criticizing strangers. I was not criticizing, whoever. I was criticizing the same officials, the same offices, the same lawyers, the same police actors, and public systems that later became involved in the criminal process against me. Now, that's why fairness is the issue. The record also shows that the law departments, had advance notice. My attorney's motion states that on December 29th, there was correspondence sent to the law director, placing him on notice, and the law department of alleged constitutional violations, as I said, public records obstruction, retaliation, dual role concerns, structural bias, and the supervisory failures. That notice matters because it came before the March 11th, 2026 Butler hearing, before the March 12th carry-on protection order activity, and before the March 20th criminal filings, and before the March 23rd phone warrant and passcode communications. The city cannot honestly claim it was surprised by the conflict argument later. The law department was warned before the criminal escalation moved forward. That timing is devastating to the idea of neutrality. Once the law department was placed on notice that its own conduct, supervision, records, practices, and overlapping roles were being challenged, it had a duty to pause, screen disclosure, seek independent review before continuing the criminal prosecution. Instead, according to what the motion states and the records we have, the same municipal legal structure continued forward. It started out with a particular prosecutor in charge, but now that prosecutor, while being the lead prosecutor, is only mentioned in the filings, where it seems that the second chair is now Scott Bowles, the guy that was involved in the civil case that led to the roadmap, that led to the next case that has Mr. Safety Service Director being represented, I believe, by Mr. Levesque in that matter. And then now Bowles is second chair in my criminal matter. Look, I'm not saying it's unfair. I'm just saying, you'd be better off putting a one-legged man in a race against a dude with 8 legs, because that's what it feels like. The strongest part of this filing, though, is it doesn't ask the court to decide every civil rights claim, every public records dispute before the trial. It asks the court to answer a narrow, more urgent question. Can the same office that's participated in events, defended the officials, controlled the records, advised the police, shaped the city's response, now exercise detached prosecutorial judgment against the same person, yours truly, who exposed them and challenged those actions? The motion says the answer cannot be assumed. It has to be tested through disclosure, a hearing, and a record. And that's why this whole episode has to begin with conflict, not chronology. The chronology matters, and we'll walk through it. But the deeper truth here is the process was contaminated before the newest charge was ever filed. The city and the county did not simply investigate a criminal complaint. They had already been watching me, collecting my complaints, responding to my public records requests, circulating narratives about me, defending against my lawsuits, questioning my professional status, challenging my media role, reacting to my reporting. And by the time the criminal case arrived, the system had already formed an opinion about who I was. A fair process examines evidence first and reaches conclusions second. What happens here looks backwards. The government built the conclusion it wanted first, and then it kept looking for the legal vehicles to support it. First, I was always framed as a problem. Then I was framed as vexatious. Then I was framed as unhinged, their favorite word. Then my professional fitness was questioned. Then my access to City Hall was restricted. Then my conduct was discussed as my potential stalking or criminal activity. Then my phone was seized. Then my speech became telecommunications harassment. Then the phone became a criminal tool. Now the same evidence process is being used to support tampering and obstruction allegations. That's not fairness. That's a momentum. And government momentum is dangerous when it's driven by the people who already had a stake in the outcome. Prosecutors are supposed to seek justice, not protect the city's prior decisions. A law department is supposed to know when its own involvement makes independent prosecution impossible. A police investigator is supposed to be detached, not part of a long-running narrative pipeline in Mr. Galinas. I mean, he's literally the longest pipeline of the whole thing because he goes all the way back to when McCann started this. And a public office is supposed to produce records, not control access to evidence that may expose its own conduct. A court's supposed to review the process, not inherit a contaminated record and pretend the contamination is irrelevant. That's why I say the prosecution should not be happening in this posture. Not because I am above the law, as much as my young daughter sometimes thinks I am. But not because public officials cannot complain, because they can. Not because speech has no limits. Not because courts cannot issue orders. It should not be happening in this posture because too many of the people driving the process were already had a dog in the fight. I think, or how was it? I read in one of the motions earlier, a canine in the hunt. I don't know. The prosecution is asking for the public to trust a structure that has not earned that trust. The record shows prior conflict, prior notice, prior legal disputes, prior records battles, prior disability notice, prior employment consequences, prior media disputes, prior city hall restrictions, prior judicial appearance and issues, and prior law enforcement involvement by the same recurring actors. That is why the conflict question is not a side issue. It's the center of the case. The cleanest way to say this is they were never outside the story. They were always inside it. I feel like they were writing it, but that's going to bring us to section 2, folks. Right back to the law department was not outside the controversy. The first place that this conflict has to be understood is that the law department itself, because the law department's not like any background office in this story. It's not like some distant legal department that received a completed police file and then made a clean charging decision, right? The record that the filing shows something kind of entirely different. It shows that an office that appears again and again and again across the same factual universe wearing different hats depending on the city needed at the moment. That's the problem right there. The Lorain Law Department has actually appeared as civil defense counsel. It has appeared as legal advisor to city officials. It has appeared in public records disputes. It has appeared in city hall access disputes. It has appeared in municipal property ban disputes and issues. It has appeared in the police advisory roles. It has appeared around the protection order issues. It has appeared in media and public narrative concerns. It has appeared in outside counsel conflict determinations. Then after all of that, it appears again in the criminal prosecution structure against me. The motion says it plainly. This same municipal legal office that appears across civil defense, public records control, police advice, witness adjacent matters, protection order issues, media related concerns, outside counsel conflict determinations, appellate litigation, and criminal prosecution, period. End quote. That's not neutrality. That is role blending. A prosecutor is supposed to stand apart from the controversy. The prosecutor is supposed to review the facts with detachment. The prosecutor is supposed to seek justice, not prosecute the city's prior decisions. Or protect the city's the prior decisions, not defend the city's public image, not preserve the civil litigation positions, not shield records decisions, and not validate earlier actions by city officials. When the same office is already defending the city and its officials, advising the police, handling records, responding to my lawsuits, interacting with witnesses, and controlling information relevant to my defense, it cannot simply walk into a criminal case and ask everyone to pretend none of it matters. The motion identifies that exact defect. It explains that the law department's public records role creates a direct conflict because the same office now involved in prosecuting me may also have controlled, reviewed, delayed, denied, redacted, justified, or litigated access to records relevant to the criminal defense. That includes records concerning city legal expenditures, litigation positions, police communications, city hall incidences, municipal property directives, media communications, body camera releases, and communication between the city and law enforcement. Those records are not collateral. They're part of the evidence map. They reveal motive, timing, selective enforcement, witness credibility, retaliation, probable cause problems, or whether the city was treated me as a records requester or as a target. My daughter says that she thinks you made me a target. I think she's right. That's why this whole thing's wrong. The same office that may have kept records from me cannot then prosecute me while pretending those records have nothing to do with the case. The same office that may have shaped the city's public records position cannot then decide what I get to see in discovery. The same office that may have defended public officials cannot decide whether those officials are simply witnesses, alleged victims, protected persons, or credibility problems. The same office that advised the police cannot later then claim it had no role in the way police built the case. The law department cannot be the gatekeeper and the prosecutor at the same time. The motion also points to a very specific public records admission in the Lorain County Common Pleas in case number 26, Charles Victor 00053. In that case, the city admitted that I appeared at Lorain City Hall on at least 3 occasions and demanded to inspect records, and I was told by Attorney Bowles or Attorney Zaleski that I could not examine them. The city also admitted that it never informed me that no responsive records existed, that it did not provide a record denial citing a specific statutory exemption that matters because the same municipal legal structures now involved in prosecuting me participated in denying inspection of public records. They failed to provide the statutory explanation required when records are withheld. That admission cuts deep because it shows the records fight's not something I invented for the criminal case. It exists before the criminal case. It involved the same city. It involved the same law department. It involved the same records relevant to the same broader disputes. It involved in-person inspection, denial of access, and the city's own later admissions. When that same legal office later prosecutes me, the court cannot just assume neutrality. It has to also ask who participated, who knew what, who made what decisions, and which decisions, who handled which records, and whether those same people touched the prosecution. Without that clarity, this motion makes the point that public records are not background paperwork in this case. They are central. They are the evidentiary map of this city's conduct towards me. That is the right phrase because the records show how the narrative developed. They show who communicated with whom. They show whether officials were coordinating. They show whether complaints were treated differently depending on who made them. They show whether the city officials and the city attorneys had prior knowledge. They show whether the criminal case emerged from neutral evidence or from a long-running municipal response to my protected activity. Be nice. Do that. That is why the law department conflict's not abstract, folks. It's not just that I sued and I'm suing the city and all of the complainants involved in this matter before they ever brought criminal charges against me. The same legal department appears in the events that led the prosecution, the records that may explain the prosecution, the city's defense against my claims, the advice given to officials, and the criminal prosecution itself. Now, once that happens, the office neutrality is not something the court can assume. It has to be proven. The law department's own structure makes the conflict worse. As the motion cites, the city's own materials describing the law department's roles. In 2022, the report of the law director of the city's prosecutor's office is described as representing both the state of Ohio, city of Lorain, and prosecuting criminal and traffic violations within the city's territorial jurisdiction. The same report states that prosecutors work with Lorraine's police officers and the Ohio State Patrol to determine appropriate charges and present those to the judges. The motion then notes that the civil division included Donald Zaleski and Joseph Levesque, and even though they were located in the civil division, they covered cases for the Lorain City Prosecutor's Office. It also identifies Levesque as continuing to work for the Lorain Police Department legal advisor by providing daily legal services to the police. That structure matters because it proves that the overlap's not imaginary. Civil lawyers covered prosecution work. A civil attorney also provided daily legal advice. Prosecutors worked with police on charges. The law department defended the city, handled the records, advised the police, and prosecuted the cases. That's not a clean separation of functions. That is one municipal legal machine moving through different roles while dealing with the same person, the same disputes, and the same evidence. In a normal case, that might just be an administrative structure, right? But in this case, it becomes a conflict structure because the person being prosecuted is the same person who challenged the city's records practices, who challenged city hall restrictions, who sued the city, is suing the city, criticized city officials, is suing city officials, raised disability issues that have never been addressed on multiple occasions, filed complaints, and exposed the overlapping roles of those same offices. The issue is not whether Lorain has a law department. The issue is whether that law department can prosecute Aaron Knapp after its own conduct and institutional interests become part of the factual controversy. The answer should not be assumed. It should be tested. The ethical rules make that even more important. As the motion discusses under Ohio Rules of Professional Conduct 1.3, 3.4, 3.8, 5.1, 3.7, those rule matters because this is not just about whether one lawyer dislikes Aaron. It's about candor, fairness, supervisory responsibility, evidence access, special responsibilities of prosecutors, and advocate witness concerns. 3.4 prohibits obstruction and other parties' access to evidence or concealing material, potential evidentiary value. 3.8 recognizes that prosecutors have special responsibilities that are not ordinary advocates. 5.1 addresses supervisory responsibilities within government legal office. 3.7 addresses the advocate witness problem when a lawyer's own knowledge or participation may become irrelevant to the case. That's why the law department cannot just simply say, hey, trust us. We got this. Trust is not the legal standard, folks. Disclosure is, screening is, independent review is, a record is. The court has to know which attorney touched which issue, which attorney handled records, which attorney advised police, which attorney advised or appeared in the civil case or cases, which attorney communicated with witnesses, which attorney knew about the March 11th hearing, which attorney knew about the protection order activity, which attorney knew about the warrant activity, and which attorney participated in the charging decisions. Because when you look at Galinas, he was at that hearing, that first one, and he heard the roadmap and he found it afterwards. Because without that disclosure, there's no way to know whether the prosecutor is standing in the court actually detached or merely the latest representative of a city office defending itself. But hey, the motion is careful not to ask the court to decide every public records claim in the criminal case, because that's important. The court does not have to decide every lawsuit, every records denial, every ADA issue, every media dispute or issue, or every civil rights claim before the trial. But the court cannot ignore those issues when deciding whether the law department is conflicted. The question is not whether every allegation against the city is already proven, right? The question is whether the same office accused of those overlapping actions can continue exercising criminal prosecutorial power while those conflicts remain unresolved. That is the unfairness. The law department's role is not clean. It is very dirty. It's layered. It's supervising. It's advising. It's defending. It's withholding. It is prosecuting. It is communicating. It appears in one room as civil counsel and another as prosecutor. It is protecting the city's interests while claiming to represent the state's interests. And it is managing records that may expose city misconduct while prosecuting the same person who requested those records. It is participating in a criminal case that arose only after the city's civil restriction strategy was challenged in open court. And that's why this prosecution cannot proceed on trust. If the city's prosecution is clean, then the disclosure will show that. If the prosecution is independent, then a record will show who made the decisions, who was screened, who stayed away. If no law department attorney participated in the records decisions, police advice, media releases, or the protection order discussions, witness communications, warrant issues, or civil strategy meetings involving me, then the city should be able to prove that easily. But if the same office did participate in those things and that the prosecution is not attached, then it's contaminated. That is the entire point of the motion. For the government can continue making discretionary decisions that affect my liberty, the court has to determine whether the prosecution is being handled by the neutral prosecutor or by the same municipal legal structure whose own conduct, records, advice, and institutional interests are part of the defense. The public needs to hear that clearly. This is not about technical layering. This is not about a loophole. This is about not about trying to avoid any sort of accountability. This is about whether a person can receive a fair criminal process when the prosecutor's office is also part of the story being prosecuted. Fair process requires distance. The Lorain Law Department has no distance. And that, my friends, will bring us to section 3. We're going to stop here for station identification. And the next section, I'll be breaking down each person individually as we move forward. So stay tuned and be aware. We'll be right back.
Plug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the
Alrighty, folks, that brings us back for section 3. And we're going to cut right in. I'm going to remove that. There we go. So before I break each person down individually, the public needs to understand that the cast of characters as they're connected to the structure. And it's not a case where one officer investigated, one prosecutor reviewed, one judge ruled, and one complainant reported. That would be a clean system. That's not this record. This record shows overlapping roles, repeated names, prior disputes. Repeated names, prior disputes, prior notice, prior litigation, prior records, public records, fights, prior disability notice, and prior government communications about me before the criminal process ever reached this stage, right? The simplest way to understand the conflict is this. Almost everyone touching this case has had a reason to defend the system that I've been exposing. Some were city lawyers whose office had already been accused of public records obstruction, retaliation, structural bias, dual role conflicts, and lack of candor, and supervisory failure. Some were police actors who had already participated in communications about me before later becoming involved in warrant activity or criminal escalation. Some were city officials connected to the underlying City Hall incident. Some were public officials or potentially connected complainants who had already been part of the narrative environment surrounding me. Some were court-connected actors whose offices had already touched my employment, professional role, or access to proceedings. When those people later appear as prosecutors, witnesses, protected persons, affiants, advisors, records, gatekeepers, or decision makers, the public is not looking at neutral actors standing outside the controversy. The public is looking at people already inside it. The Lorain Law Department is the center of the conflict because it's now the office prosecuting while also appearing throughout the underlying factual universe. The motion states it clearly that the law department appears across civil defense, public records control, police advice, witness adjacent matters, protection order issues, media-related concerns, outside counsel conflict determinations, appellate litigation, and criminal prosecution. That sentence matters because it explains why this is not just a complaint about one lawyer. The conflict belongs to the office itself. The office that defended city interest, handled or influenced records, advised officials, interacted with police, and appear in related proceedings that cannot simply claim a clean prosecutorial role when the prosecution arises from the same broader conflict. Patrick Riley, the law director, matters here because he is the law director, and that means he is not a random lawyer whose name appears in one filing. He is our elected person, our guy. He's been there 15 years. He is the supervisor of the office. He is responsible for structure. He is responsible for screening. He is responsible, for assignment, supervision, and conflict management inside the law department. And, the motion explains that Riley was placed on notice through a notice that was sent by Mr. Gargis long before the March 11th hearing with Butler, long before the carry on protection order activity, long before the March 20th criminal filings, and before the phone warrant even and the passcode communications. That makes his role critical because once the office was warned of alleged constitutional violations, public records obstruction, retaliation, dual role concerns, structural bias concerns, and supervisory failures, Riley cannot simply just allow the same office to drift into criminal prosecution without screening, disclosure, outside review, or independent referral. Scott Bowles matters because he appears on both sides of the line and should have separated civil defense from criminal prosecution. He was involved in the March 11th civil hearing, where the city defended the municipal property directive. He was the lead attorney. He was the one questioning me. He's the one in all of the, transcripts. That hearing involved the same city hall controversy, the same conduct, the same public meeting context, the same broader dispute that later led to fed that whole protection order criminal consequences. The motion identifies Bowles as directly implicated because his role appears to place him on both sides of the matter, prosecutor on one hand and factual participant or potential witness on the other. The motion states that he served as lead counsel for the city in the civil proceeding before the magistrate Butler, and also participated as second chair in prosecution currently in the criminal cases arising from that same factual controversy. We look at Joseph Levesque. He matters because his role is even broader than a single hearing. He was present at the March 11th hearing. He challenged the status of Mr. Knapp's media company by arguing that Ohio law protects only legacy media and that Mr. Knapp was not running a legacy media organization, and that he or I am identified, as Levesque is identified in the official rules and laws or whatever, at least in the city's rules, as assistant law director and police legal advisor. The motion goes on to explain his title alone matters because a police legal advisor is not a distant civil lawyer. A police legal advisor's position to advise law enforcement on investigations, warrants, charging issues, evidence, questions, public records matters. And if the police legal exposure, if Levesque advised police or Galinas, who were both present at that hearing, communicated with witnesses who were both all present at that hearing, participated in protection order issues, they did. They were all there that day at the protection order hearing to testify, every last one of them, including the court administrator, Jordan Coughlin. Now, all of those people are now going to be potential witnesses, their advisor, participant, or some sort of a conflict source. Donald Zaleski and Attorney Pritchard matter because the conflict doesn't stop with the lawyers whose names are most visible in the criminal case. The motion explains, and I could explain, that Zaleski and Pritchard are relevant because the public records access, inspection denials, redaction, privilege assertions, withholding decisions are part of the criminal conflict analysis. The motion specifically references the city's admission in a related common pleas matter that I appeared at Lorain City Hall on multiple occasions, demanded to inspect the records, and I was told by Bowles or Zaleski that I couldn't examine. I've had direct contact with these individuals. It notes the city admitted it never informed me that no responsive records existed and did not provide a written denial citing a specific statutory exemption. That makes records lawyers fact witnesses in the same broader criminal defense because the records disputes may show motive, retaliation, lack of candor, selective enforcement, or obstruction. Lieutenant Galinas, you're going to hear him a lot, all right? He matters. He's not clean. He's not a first-time investigator who just magically appeared here after a neutral complaint. He appears earlier in the licensing board pipeline and later in the warrant and criminal escalation. The master record that I have shows Galinas forwarding my complaints to the Ohio board, the CSW-MFT board, at the bequest of Chief McCann. And it places Galinas inside the earlier professional board narrative about me. Then March 19th, the warrant is directed to the Lorain Police Chief and to Lieutenant Kyle Galinas and other authorized officers authorizing the search for personal cellular phones. Not one, but phones. That's important because it goes against another Riley v. California. Look it up. It's belonging to me as evidence of this telecommunications harassment and possessing criminal tools. Now, that's a serious conflict concern because the officer connected to the warrant process, Galinas, had already been connected to a prior official communications about my professional status and complaints that had been dismissed. He was fully involved. And I think it's worth stating outside of my script that I had researched all the evidence on how Mr. Galinas ended up in his position. He had been part of the bargaining unit at the FOP, and then I guess McCann made some insensitive statements about fairy socks and called him Kyle Galinas, which is probably the most easiest one to hit on there as far as, no pun intended, as far as jokes went. And so I went back and looked up the article in the Scarlet and Gray that they published about him, or I think it was in the Columbus Dispatch or the Scarlet and Gray, where they talked about how McCann was given sensitivity training because of what he said and what he did, yada, yada, yada. But then later he moved Galinas into internal affairs, which removed Galinas from the actual job of being the union rep. And so there was a lot of maneuvering there. But then suddenly he goes from, the complainant to the IA guy, and suddenly he's doing all this stuff for McCann. He's also apparently was the records guy because he's been responding to everything I've ever sent for years. My former treasurer knows a lot about him too. But hey, former Chief McCann matters because he's one of the origin points for this entire retaliation pipeline. The records show that McCann communicating with my licensing board, questioning my conduct, was out of line for the profession, questioning whether my conduct was out of line for my profession. He discussed possible criminal charges. He was referencing Applewood, asking whether I was fit to be a social worker. The board later did not substantiate those allegations, but the damage from the communication had already been done. McCann also matters because the city approved taxpayer-funded outside counsel for him in my federal civil rights case. That means he's not just a former chief in the background. He is a challenged official whose prior conduct was part of my civil rights narrative and whose defense was funded through the city process. Ray Carrion matters because he is both a city official and part of the factual trigger for the City Hall controversy. The March 11th hearing transcript shows I testified about trying to report unwanted contact involving Carrion in the hallway with a door and his chest, and that I was trying to get Chief Fallon to take a report. The conflict is not just that Carrion was involved. The conflict is that when I tried to report Carrion, the system did not move the same urgency as it later did when it was used against me. Carrion then becomes connected to the protection order activity and the same broader sequence that moved forward from City Hall access to a criminal frame. A person who is part of the alleged incident and then later protection order environment cannot be treated as merely neutral background. Mayor Jack Bradley matters because he appears in part or as part of the whole city power structure and was physically present at the March 11th hearing and seated at council table. Now, say what you want. He was supposed to be there as a witness. He was seated at council table. He, along with the others, were giving advice to Bowles in regards to this whole process that I was fairly well holding my own on. I get it. I'm always at a disadvantage there because I'm always coming from a third party. That's why Judge Cook doesn't understand how I wrote what I wrote when you look at what I wrote. It's the same thing I used to do in Idaho. I have filing after filing after filing on my custody case. I always serve myself. It's a safe way to do things because it's not wrong. It's unusual, yes, but it's unusual for a pro se litigant to be as versed in the law as I am. It's taken me a while to get versed in Ohio law, but I mean, for those that, oh, he doesn't know Ohio law, he doesn't know this, he doesn't know that, he doesn't read, he doesn't have stuff. I get it. I know. You guys just, I'm boring, right? Like, this is the 2020 Juvenile Law Handbook. It's kind of boring, but, I do look through this stuff occasionally. I'm not saying obnoxiously I've read that one word for word, but I promise you I've used it to look up every single case that any one of my clients was accused of, so I understood exactly what was going on in their lives. That's what made me a good social worker, and that's what made them hate me. So when you ask, well, are you capable of writing them? I'm capable of writing that motion and tenfold. ChatGPT, everyone talks about it like it's some sort of great godsend. It's making us lazy. I'll use it for research. I'm not denying that. Everyone does. In fact, the law field's moving more towards that. So Judge Cook's reliance on, well, in the uptick of AI doesn't matter. Was the motion correct? Look, they're mad because Bowles filed a motion of, trying to get me in trouble. I responded with a motion to get him in trouble. Mine was better than his. The court denied his, didn't challenge anything. Court denied mine, but only after stating it was well articulated, was well put together, and was a good motion. And then goes on to say it couldn't have been me that wrote it. And he goes on to say that in his answer to the Supreme Court. I was reading that, I've got the paperwork back here somewhere. He says again, like, I feel so honored and at the same time so slapped in the freaking face, because he's in there going, this stuff's just way too good for Mr. Knapp to have written. I get it. It's easy to believe that everything I do is articulated through AI. And I'm not saying I've never used AI. I've got pictures up for AI. AI is a tool. Most things are tools, folks, but how you use them matters. Right? I am not stupid. I'm an educated man. I read books. I watch documentaries, and I read law books. When I first got to Ohio, the first thing I did was start educating myself on Ohio law. Everything from your gun laws to your municipal laws, because I needed to know the difference, because I have a drive to know. And it's easy for me to remember stuff. I read it, I remember it. It's not photographic, but it sure is identical. So that brings us to where we're at with all this. Yes, I do read all of these things. I do read the case law. Bob has sent me hours of case law. I could bring up, you guys would get bored by it, but I have files filled with Supreme Court case law. I subscribe to the Supreme Court website and I get all the new case law coming out. I subscribe to Judge Kimler's, he does, Judge Kimler, retired Judge Kimler, who now does a outside service stuff, but he comes in and works occasionally. He has a great newsletter, and he brings up such outside the box facts and cases to talk about that I like to read about it, because I'm always apparently involved in those. And most recently he was talking about, some cases on jurisdiction and agreeing to move jurisdiction and yada, yada, yada. So staying abreast of current knowledge is important for all people within this whole legal system. When I look at Lorain County, Lorain City, all these people, it's scary to think that how many people don't even seem to understand the law. Like, if they knew the law, they would have known about Riley v. California on the phone, and that you can't just say phones. And then the second we object to that, you seal the motion and change it. And who was involved in it? It was Galinas, because we already know it was him. We already know that he went and sat down in a criminal rule 4 hearing and didn't properly record it. Well, and that's on court administrator? I don't know. I don't want to say it's on the judge, but I mean, somebody should have been there to record it. But again, I feel like the judge is being misled by the powers that be, and that's not fair. How can you ask a judge to come in from outside the area with no knowledge of any of the players and be expected to be, just handed a case and understand everything, when it feels like the key players are being showing an extreme lack of candor? I've waived time. I've tried to move forward. I've given admissions. But hey, so how was Mayor Bradley sitting at that table, at the attorney table, not as a witness? The mayor's presence matters because this is not a low-level dispute between me and one employee. The city's top elected executive was present while the city defended a sweeping restriction on my access to public property that was eventually kicked out. I mean, again, as Judge Cook will point out, they granted my motion more or less. They relegated me like Rosa Parks to the back row, and I'm not in any way comparing myself to her in the fact that she fought for civil rights and is an amazing woman and did so many amazing things. But to put any person in the back row of any room and restrict their seating feels very institutionally wrong. But, when you look at that places the dispute at the highest level of the city government. It reinforces why the city's later prosecution cannot be treated as separate from institutional self-defense. Chief Fowling matters because he appears at February 16th City Hall sequence and the broader law enforcement response. In the March 11th transcript, I testified that after the alleged contact by Carrion, I tried to get Fowling to take a report. He said, I said, give me Fowling. I want to charge him. The record shows I identified Fowling as the law enforcement officer present on scene. He was. And that whether he saw it or not, he was present. That makes him relevant because he was present during the incident, and that makes him part of the later city narrative. If he did not take or pursue my report with the same force later used against me, and they didn't, that disparity is a fairness issue and a potentially a witness issue. When you look at the Tim Weitzel, the juvenile court judges matter because this story is not just confined to City Hall. You go back to July of 23 and the email from Weitzel to Applewood states the court identified concerns regarding me as a therapist, references to officers of the court, allegation that states that after careful consideration, elected judges, the court requested that I be removed from Crossroads and replaced. That is a court-connected employment consequence tied to the same narrative that began with police and professional board communications. If the juvenile court administrators and the judges were already involved in a professional consequence against me, then the later government, the narrative about me cannot be understood without that history. The Lorain County Prosecutor's Office matters because the conflict issue was not new. The Carrion investigation packet includes February 6, 2024 letter from the Lorain County Prosecutor's Office. And in regards to other issues, stated that it already had a conflict with me or apparent conflict involving me after a courthouse prosecutor lobby incident, which we won't even get into here, and later advice to domestic relations and juvenile court judges on me. Now, that document's important because it proves the conflict issue had already been formally recognized before the current prosecution environment. It also connects the county side of the story to the city side of the story because the same broader controversy involves the courthouse video, public records fight, prosecutor involvement, and the government actors who have acknowledged now the conflict concerns. The complainants and the protected persons matter because several are not simply private individuals in a vacuum. Some are public officials, political actors, government-connected figures, or people who had already been part of the broader narrative about me. Now, the conflict issue does not require saying that every complainant lied or that no one can ever feel afraid. The point is that the criminal case built fear. It was built on fear, interpretation, public speech, third-party circulation, political context that really must examine motive, prior contact, monitoring, and whether the alleged exposure came from me, from others, distributing, the public content. If people were monitoring my pages, which they were, it's been clearly shown. Some of the victims in here have either people monitoring them or monitoring themselves or constantly trying to add them. If they were monitoring, receiving content from third parties, discussing me with officials, or participating in the same political environment, their role has to be tested rather than accepted at face value. Magistrate Butler and Judge Cook matter because the court process itself became part of the conflict sequence. They can argue what they want, but the March 11th transcript shows Magistrate Butler, saying she was appalled by the behavior and it could be a subject of a civil stalking protection orders, which it became, and that it may rise to the level of a criminal matter, which it became, while also recognizing the city did not appear to have the proper vehicle to impose the broad ban, which they didn't. The later disqualification and recusal issues don't require proving personal bad faith on either of their halves. Judge Cook's like, well, I don't have any issue with Mr. Knapp. I get that. What they require looking at is whether the record creates a reasonable appearance that the court had already formed views about the conduct that later became tied to a related proceeding. That's why judicial peace is not separate from the conflict analysis. It's the same sequence. That's why when judges try to argue, oh, well, I just da-da-da-da-da-da-da. No, you commented on the record. When you comment on the record, it's a big deal. You can't just dismiss that like your words don't matter. They do. The disability issue ties every player together, though, because the city and its officials had noticed. The county knew. The record includes my testimony that I provided the city my medical documents. I warned them when I was triggered. I elevate my voice and repeat myself. The VA decision later found service-connected PTSD, generalized anxiety disorder, and TBI severe enough to support individual unemployability and permanent and total disability status. When government actors have that information and they continue using triggered responses as evidence against that person, fairness requires scrutiny. It requires the court to ask whether the government accommodated, de-escalated, or intended, or instead it exploited known disability responses. That's the cast of characters, not one isolated actor, not one mistake, not one bad day. The Law Department, Patrick Riley, Scott Bowles, Joseph Levesque, Donald Zaleski, Attorney Pritchard, Lieutenant Kyle Galinas, former Chief McCann, Safety Director Carrion, Mayor Bradley, Chief Fowling, Tim Weitzel, juvenile court judges, the county prosecutor's office, complaints, protected persons, the judicial actors all appear in different ways inside the same conflict. Excuse me, and environment. Some should be screened. Some should be witnesses. Some should be disclosed. Some should be recused. Some should be removed from any prosecutorial role. Some should be examined in an evidentiary hearing before this prosecution goes any further, not 1 inch further. And this is why the next sections will, we're going to go through and name each person. We're going to explain the conflict one at a time. The public needs to see how these machinery worked. The court needs to see why general assurances are not enough. And a criminal prosecution cannot proceed on trust when the record itself shows overlap this deep. The state cannot simply say, well, we're neutral, when the documents show that nearly every major player had prior involvement, prior interest, prior exposure, prior contact with the same controversy, myself included, my attorney included. A fair system would have brought in an independent prosecutor before the damage spread. The system kept going. So that's going to bring us to Section 4. And before we move on to Section 4, I'm going to break these podcasts down into several different hour-long sections. So this has been an hour and 11 minutes. That brings us to the end of our first podcast on this matter, bringing to the beginning of Section 4. When we come back, we're going to be discussing Section 4, Patrick Riley and the conflict of supervision, and how he's not just some other lawyer, like how he's involved as the lead attorney in regards to the gun law case, our case at the Superior Court. All of these different cases tie back into the law department. What we're going to do is, as we continue this podcast series, we're going to go through each individual player. We're going to discuss their involvement, where they're at, how they got there, and why we should, as a public, be concerned with it. So again, I thank you guys for tuning in tonight, and tune back in or today. I'll be doing the next one here shortly, but in terms of when you get it, I don't know, but we're going to get that next one up and going. In the meantime, thank you for tuning in tonight. And this has been a podcast of Knapp Unplugged. Thanks for tuning in, and we'll see you guys next time.
Noise, no script, no leash, no polished decoys. Broadcasting without permission, we don't ask. We lift the curtain and we drop the mask. Unplug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission, we don't ask. We lift the curtain and we drop the mask.